case.
Auxin, LLC et al. Versus DW Interest, LLC et al.
Good afternoon.
Good afternoon, Your Honor. Prepared to proceed?
Yes, sir.
My name is William Scales, and I represent the appellants in this matter, DW Interests, LLC, and David White. I would like to reserve 2 minutes for rebuttal, if I may, please.
2 minutes, yes, sir.
This is a commercial real estate dispute in which the appellees filed a declaratory judgment claim and the appellants filed counterclaims for both fraud and for breach of contract. At the trial court level, the appellees filed 2 motions that disposed of the entire case. The first was a motion for judgment on the pleadings, and through that motion, the trial court granted their declaratory relief and also dismissed the appellant's fraud claim for lack of specificity. The second motion that was filed was a Rule 12.026 motion, and in the alternative, a Rule 56 motion. The trial court granted that motion. It denied the appellant's Rule 5607 motion to continue, and it granted in the alternative the Rule 56 motion. Today, Your Honor, we're asking you to reverse those 2 rulings. With respect to the motion for judgment on the pleadings, we ask you to reverse that for 2 reasons. The first, the denials and the affirmative defenses in the appellant's first amended answer created issues of fact that precluded judgment on the pleadings. The second reason is with respect to the fraud claim, an analysis of the counterclaim demonstrates that it contains the appropriate level of particularity. Turning to the Rule 12 motion and the alternative Rule 56 motion, there are 3 reasons that this court should reverse. The first, the Rule 12 motion considers matters outside the pleadings, which requires that they be converted to a Rule 56 motion. The Rule 5607 motion should have been granted because if you apply the correct standard, we satisfy that obligation. We maintain the court abuses discretion. And then finally, with respect to the Rule 56 motion, the declaration that supports summary judgment and the final order both contain procedural defects that render them defective and subject to reversal. Would the court care for a recitation of the facts before I proceed with addressing the actual merits?
We've read the briefs, but I'll leave it up to you on what you want to cover.
Thank you, Your Honor. So turning now to the denial and affirmative defenses that were a basis for the motion for judgment on the pleadings. As the court is aware, the standard is that all well-pleaded facts are accepted as true. All reasonable inferences should be drawn in favor of defendants. The court should have treated as false all the plaintiff's allegations that the defendants denied, and conclusions of law are not admitted. In the first amended complaint, there are denials of each of the material allegations in the declaratory judgment complaint. And so based on those denials, judgment on the pleadings should not have been available. In addition, there were affirmative defenses that, if proven at trial, would negate the declaratory judgment action. So at that particular stage, the judgment on the pleading stage, those denials and affirmative defenses should have rendered motion for judgment on the pleadings unavailable.
So one of the items that declaratory relief was requested on was the fact that this purchase agreement was terminated. What in the pleadings prevented the court from concluding on these pleadings that this agreement was terminated?
The agreement itself contains no self-effectuating termination provision. It does include a feasibility provision that if certain actions were not taken during the feasibility period, that the option agreement that's at issue here would be triggered. But we maintain that there were actions that the appellants took, the appellees took, that hindered our ability to do that they didn't satisfy their own obligations, and that breach prevented us from satisfying that feasibility period.
Was that obtaining the financing, the favorable financing, or was it some other facts?
Good question, Your Honor. It is so there was TIF funding, so tax increment financing, there were new market tax credits, and there were additional financing. The TIF was actually, the nature of the TIF they obtained was not consistent with what the expectation was of the parties. The expectation of the parties was that the TIF finance or the TIF money would be for the hotel project, which is defined as the hotel and the conference center. It was not the parking garage, which was the subject of the TIF that was obtained. And the parking garage was a private parking garage intended for public use. The other thing is the amount of TIF that was made available was generally available. It wasn't specific to this particular project. So anyone who owned property in that zone where the TIF was made available could request those TIF funds. In terms of the new market tax credits, those were never obtained. You'll see in the record, it's Exhibit F to Robert Duncan's declaration. There's a letter from Community Trust Bank in which Community Trust Bank says, to whom it may concern, we are interested in new market tax credits. Not we're going to give you new market tax credits, not this is a letter of intent, none of that. So the funding sources were not obtained, and that's part of what hindered the ability to make this project move forward.
And so were each of those elements conditions of the purchase agreement?
Those elements were contained in the development agreement. The development agreement was between Auxin LLC and DW Interests, and they were specifically enumerated as things that Auxin had to do, and they did not do them.
But obviously there's a different party to the purchase agreement than under the development agreement, correct? Because
Yes, sir. So I'm sorry.
I was just going to ask, so how does that carry over then to prevent at least a declaratory judgment on the issue of termination?
As to the issue of termination, again, Auxin Wilson Project, which is the party to the real estate purchase agreement, is a wholly owned subsidiary of Auxin LLC. So effectively, Auxin controls what Auxin Wilson does. And because Auxin did not follow through on its obligations, effectively that hinders, again, the appellant's ability to follow through on their obligations, which is a breach of that particular agreement. And so that's why we maintain that termination could not be determined, because in order for that to be determined, determination to happen, and it allow the option to go forward, there can't be kind of a first material breach by the opposing party. Does that answer your question, Your Honor?
Yes, sir.
With respect to the denials and affirmative defenses, this particular case finds support in the Landry's Inc. versus Coin Mock Corp case. In that case, the Landry's party filed a complaint, and in that complaint, they asserted that a $150,000 note had not been timely paid. The defendant in that case, Coin Mock, responded, or at least answered the complaint, and says, we agree we executed the note. We agree that we have not paid the $150 yet, but we deny that the note was due and owing, and we deny that all the obligations required to effectuate maturity had occurred. And on that basis, this court found that the motion for judgment on the pleadings was improper. Here, as we've discussed, the motion for judgment on the pleadings is improper because the denials and affirmative defenses negate and create issues of fact that prevent judgment on the pleadings. In terms of particularity with respect to the fraud claim, a review of the counterclaim demonstrates that Rule 9.02 is satisfied. We submit that Tennessee's common law requires time, place, and manner of the representation to be provided in the pleading. And if you look at paragraphs 15, 16.1, and 17 of the counterclaim, you have allegations of false statements of material fact, who made the false statement, and when that statement was made. So that is the time, place, and manner of the representations.
But aren't they conclusory statements? What component of 15, 16.1, and 17 do you contend to represent specific facts or facts set forth with specificity?
Thank you. So in terms of 16.1, it again references back to the development agreement and the specific enumerated provisions in the development agreement that weren't satisfied. We maintain that Auxin's principal executive, a man named David Allen, made these representations directly to David White, who's another appellee and the owner of DW Interest, that they would acquire these financing things. So we talked about the TIF, new market tax credits, and assist with the financing. And so we've identified specifically those items which were
But
representations.
saying you're going to acquire financing is saying that you're going to try to do something in the future. And fraud usually contemplates a misstatement of an existing fact.
I don't disagree with that, Your Honor, but to make the representation as though it will happen, they were going to make this happen, and then to not intend to do it or not fully go through with it, we submit would be fraudulent.
Okay. Now, I noticed in responding to the motion for summary judgment, your client did not file a response other than a motion for the hearing to be continued. Why should we overlook the fact that after 2.5 years, your client was unable to file a response to a motion for summary judgment?
The standard for a Rule 5607 motion to continue, the period that's evaluated is the period between the time the summary judgment motion is filed and the time of the hearing. That's the Everett versus McCall case. And in that case, the court made clear that a party resisting a motion for summary judgment must be given a reasonable amount of time. They relied on the Byrd case in that case to make that pronouncement. Here, I guess in the McCall case, there were about 39 days between the date the motion was filed and the hearing date. Here, there's only 32. So there was an insufficient amount of time to conduct the appropriate discovery.
But the rules contemplate 30 days, so what you're saying is under every situation, a party would be entitled to more than 30 days, which would make the rule useless.
If the party...
Don't you have to come forward with some factual representation other than I need more time?
Yes, you do, Your Honor.
And what facts did your client set forth to justify a continuance of the hearing?
So as appended to the Rule 5607 motion, there were two declarations. One from lead counsel in this case, Brian Williams, explained why that information could not be attained in 32 days. And the second was David White's declaration that said the specific information he believed could be obtained through discovery. And my understanding of Rule 5607 is that if your declarations provide the why and the what, that satisfies.
But the trial court seemed more influenced by the fact that your client had let 2.5 years go by without doing discovery.
This is true, Your Honor. But again, if you look at the Everett versus McCall case, there was a similar delay in time. But again, this court found that the focus should be what actions were taken between the time the motion for summary judgment was filed and the time of the hearing, Your Honor.
Okay, all right.
I will conclude briefly as my time is running out. We asked the court reverse the motion for judgment on the pleadings for two reasons: the denials and affirmative defenses create an issue of fact, and the fraud claim was pled with specificity. In terms of the Rule 12.02 motion, Rule 56 motion, the Rule 12 motion considered matters outside the pleadings, which should have converted it to a Rule 56 motion. The Rule 5607 motion was an abuse of discretion to deny it, and there are procedural flaws in the Rule 56 ruling.
All right.
Thank you for your time, Your Honor.
Thank you, Mr. Scales. Good afternoon.
Good afternoon, Your Honor. It's a pleasure to be back here in person.
Yes,
I
sir.
much prefer it. I will start briefly, Your Honors, with the motion for summary judgment, then talk about the Rule 9 dismissal of the fraud claims, and then get to the declaratory judgment, if that please the court. The motion for summary judgment, as the court has obviously noted, there was no substantive response filed to that at all. I think it's important to note, and as counsel said today, DW Interest is a one-man operation. It's David White. David White is the one who filed this affidavit requesting additional time. He's the one that these alleged fraudulent statements or misrepresentations were made to. There's no reason that David White could not have filed an affidavit saying, I was lied to. Somebody told me this on this day, somebody told me this on this day, somebody told me this on this day, and none of that was true, in order to create a disputed fact. He didn't do that. And Rule 56.07 requires a person seeking additional time to set forth specific reasons why they cannot set forth those facts to create the genuine issue. And they didn't do that. And so Rule 56.07 grants that discretion to the trial court not to grant the extension. The F&M Bank versus Fleming case is an important case because it talks about that period of time, 2.5 years, that they had to do discovery and elected not to do it. Again, they didn't need to do any discovery to tender the declaration or affidavit of David White to say what lies he'd allegedly been told, but they had 2.5 years to do it. F&M Bank explained why Everett is not applicable here, the case that appellants rely on. The Everett case talked about was a case where an expert had to be marshaled to respond to the movement's expert. In order for that expert to render an opinion, to be able to tender an affidavit, they had to review the deposition of one of the parties. And so there was a reason articulated in the affidavit as to why things had to be done in a staggered fashion that they weren't able to do within that 30 days that the rule requires. That doesn't exist in this case. F&M Bank said that you don't look just from the date the motion is filed until the date of the hearing unless there's some extenuating circumstance like there was in Everett. And so I'd submit to the court that the trial court's discretionary decision not to grant an extension of time should be affirmed. And the motion for summary judgment under the Holland versus Memphis case, failure to respond to that substantively is generally fatal to someone's position on motion for summary judgment, both at the trial level and on appeal. As for the motion itself, it was a motion for summary judgment or in the alternative Rule 12. And the reason we did that is because this case had been plagued with delays and we didn't want any further delays. The declaration of Robert Duncan, which is attached in support of the motion for summary judgment, it sets forth all the facts that are necessary to grant the motion for summary judgment. And so, of course, a non-moving party cannot rest on their pleadings, which is exactly what the appellants did in this case.
And when you refer to the motion for summary judgment, are you referring to the motion to dismiss the fraud claims?
The motion to dismiss the counterclaims, the breach of contract and whatever was left of any kind of fraud claim. And that was also a Rule 12, alternatively a Rule 12 motion. They've challenged in their brief the fact that the court relied on public records. I think it's pretty well established that a court can rely on public records on a Rule 12 without converting it to a Rule 56.
But can you rely upon municipal ordinances?
So you can't rely on municipal ordinances according to the Supreme Court's case from 1973, but you can rely on the fact that something occurred. In other words, it's not that the contract, the developer agreement requires people to make best efforts. It doesn't require them to guarantee TIF financing.
What public record would show that any of these parties made best efforts?
The minutes of the meetings of the county commission and the city council where the TIF financing was approved, the photograph that from the newspaper article that showed the Auxin representative at the city council meeting making the effort regardless of the outcome. In fact, it was all approved. So those public records, I think, show that there was a TIF district. And I think that is something that the court can rely on as a public record, notwithstanding the fact that you wouldn't normally rely on an ordinance.
Now, the newspaper articles, how in the world do we rely upon them?
And so
how does that not constitute hearsay?
The trial court didn't. And so if you read the trial court's order, he said, I'm going to disregard the newspaper articles. I'm simply going to rely on that these records show that something happened. I'm not going to rely on them for the substance inside them. I'm just going to rely on the fact that something happened. And
I'm not sure I see the difference.
Well, with respect to the
How
newspaper
do you know
article,
that something happened unless it was a hearsay declaration?
With respect to the newspaper article, that's probably true. With respect to the minutes of the meetings, I think that the trial court can rely on those just the same as the most common example I have in my practice is when people file discrimination claims, the EEOC's charge of discrimination is routinely considered by the court. The right to sue notice is routinely considered by the court. These minutes of the public meetings, I think, are public records in that vein, and I think they're appropriate. But it doesn't matter.
But that would go to show that a representative showed up at this meeting and requested the TIF.
Exactly.
Okay.
And which is all that the developer agreement required. And again, of course, the court granted summary judgment supported by the affidavit of Robert Duncan, to which no response was filed. And so I think that ruling is supported, whether you call it Rule 12 or Rule 56. Importantly, the developer agreement, which they claim was breached, it provides on page 409 of the record that my clients, the appellees, would only be liable for fraud, gross negligence, or willful misconduct. Simply failing to adequately assist would not be one of those things. They would have to do something egregiously wrong according to the terms of the agreement itself. And so I think that motion for summary judgment should be affirmed. With respect to the Rule 9 dismissal of the fraud claims for failure to be specific, I think the court's identified that there really isn't anything in those paragraphs 15, 16, 16.1, or 17 that is specific. Today, counsel for the appellants told the court that it was David Allen who made the statements. Mr. Allen's name does not appear anywhere in that counter complaint. When the statements were made, what the statements were is important, and they're omitted. It simply recites the provisions of the contract, nearly verbatim, the duties listed in the developer agreement. But those aren't statements of material fact, and it certainly doesn't say how the appellant relied upon those statements of fact to the detriment. To the extent it refers to a date of these alleged statements, the date listed is March 16th, 2022. That's the date that the developer agreement was signed and the real estate purchase agreement was signed. Again, all three of these agreements, as the trial court found, and as the court obviously is aware, are fully integrated agreements that say that there are no promises or representations or other statements here.
Are they cross-defaulted?
I'm sorry?
Are they cross-defaulted? Are there cross-default
If you
provisions in the
breach on
agreements?
one, does that breach the
No,
other?
I don't think it does. Each agreement stands on its own, and they don't reference the others.
Well, you have multiple parties, which Judge McBrayer got to earlier, so how can a breach by one party to one of the contracts constitute a breach by a different party in a different contract?
And so my client didn't sue for breach. My client says that the agreements are terminated and self-effectuating, and so they're the only ones who've
And
claimed
they're
a breach.
terminated because,
There's two, so here's the walkthrough. The real estate purchase agreement was terminated because the feasibility period expired and the property was not closed on.
And that's the 24-month
And that's the
period.
24 months, and then I think they have an additional 30 days to close. As the complaint establishes, it was over 3.5 years. That time had long gone. In addition, the real estate purchase agreement says that the only two outcomes are termination or closing. So in the event of a default by my client, the remedies by the appellants are either to waive the conditions and close or to terminate the agreement. So the agreement by its own terms terminates if they did not close for either reason, for failure to comply with the feasibility period or failure to close. Those are the only choices under paragraph 15C.
if I may, then on your motion for judgment on the pleadings, the answer, the first amended answer, denies many of the material allegations in your complaint. So how do you prevail on a motion for judgment on the pleadings in the face of a denial of a factual statement?
Well, so the only real issue before the court on the declaratory judgment was, number one, whether there's a genuine dispute, which they admitted. Number two, whether declaratory judgment was appropriate, which they admitted in paragraphs 23 and 24. The interpretation of the contracts is a pure question of law. They're not dependent upon any of the facts that are alleged. I don't think that they denied anything that is material, but even if the court assumed they denied everything and assumed that the affirmative defenses denied everything, the contracts still speak for themselves, which many of their responses say. The contract speaks for itself, the option agreement speaks for itself. The operating agreement is a boilerplate operating agreement except for this paragraph 14.8 that creates the option. It's otherwise just a normal operating agreement that you'd see in any LLC. It doesn't have any real obligations that relate to this at all. That paragraph 14.8 says that if the property, both properties, cannot be developed for one hotel convention center, then Auxin will receive all of the properties in order to be able to develop it for another purpose.
And the termination event that you rely upon is triggered by the 24 months. The deal just hasn't happened. 24 months have expired, so this agreement has terminated by its own term.
Exactly. And so then reading the option agreement and the operating agreement, because it cannot happen upon a determination that both properties cannot be developed, then Auxin owns the entire Cookeville Downtown Hotels LLC that operating agreement governs. And so it's all self-effectuating, and there isn't any fact that's necessary for a resolution.
You said there isn't any fact, but there is fact. I mean, the fact that time has elapsed. I mean, you've got to make some allegations about, well, nothing was sold during this period, or the closing didn't happen. I mean, there are facts that go into that. We don't just look at the agreement and say, oh, it's terminated. Otherwise, it would be agreement to terminate. There are some underlying facts here.
Well, and those are admitted.
Okay.
So in the answer to the counter complaint, those facts are admitted. They admit that it's been more than 3.5 years. They admit that they didn't close, and they admit that they didn't intend to close. So all three of those are expressly admitted. So because those are questions of law, the court could grant judgment on the pleadings.
But don't they say it didn't close because of your client's errors and omissions?
That's what he says today. But if you look at the real estate purchase agreement in that feasibility period, there are no obligations on my client. First of all, the counterclaim doesn't say that. That's what he's argued before the court today. The counterclaim doesn't make those specific statements. But even if you took that as true and said it was in the counterclaim, the feasibility period in paragraph 7, it's on page 5 of the real estate agreement, that all of the obligations in that feasibility period are on appellants. They're not on my client. The only thing that even comes close to being an obligation on my client is that appellants will have a right to physically inspect the property. And it doesn't say my client has to make it available, but even if you assume that's implied, there's no allegation in the counter complaint or otherwise that my client didn't do that. And so there is no obligation on my client.
And I want to make sure I understand your position clearly. You're saying that even if there were misrepresentations with respect to the development agreement, that wouldn't matter here. The purchase agreement certainly terminated.
The purchase agreement of the real estate terminated, which is with the different LLC entity. That then, under the option agreement, provides that my client will become the controller of this Cookeville Downtown Hotels to develop property elsewhere. Then if he claims there's a breach of the developer agreement, they can sue for that, and did sue for that, and that case remained pending for 2.5 years until it was resolved on summary judgment.
Right.
So that all of it works appropriately. The Avenue Bank case is the one that says that just a blanket denial isn't necessary to prevent a motion for summary judgment, or excuse me, a motion for judgment on the pleadings. The Cherokee Country Club case versus the city of Knoxville, that went to the Tennessee Supreme Court, I'd say is probably one of the more hotly contested cases that have been around. There are lots of denials in each of those cases. In Avenue Bank, the court reflected that the denial said the person asserting the contract said that the person allegedly denying the contract said that the conditions precedent had not been met. They made that affirmative representation. The court said, no, the interpretation of a contract is a pure question of law. We just need to look at the contract, and we're going to disregard that statement in the answer because that's not a statement of fact, a denial of fact. That's a denial of something that the court can legally determine. The same is true with Cherokee Country Club. The city of Knoxville denied that they had done anything wrong over and over again in that answer, as is reflected in the opinion. But the court said, well, even if you characterize this as having properly followed all these legal procedures, these are just questions of law, and your denials don't prevent judgment on the pleadings. I'd submit to the court that there would be no judgment on the pleadings. That wouldn't even exist as a feature if just saying denied in an answer could prevent the entry of judgment on the pleadings. As you know, there are no cases where people agree. There wouldn't be, our courts don't do advisory opinions. There has to be some dispute to even have a case in court. So a denial doesn't prevent a motion for judgment on the pleadings, or there'd be no such thing. I'm well over my time, and I apologize.
All right. Thank you, Mr. Rader. Mr. Scales, your rebuttal.
Thank you, Your Honor. I just want to hit 3 key points first. The development agreement contains one additional feature that could be breached, and that's breach of trust. Mr. Rader identified fraud, gross negligence, but it is also breach of trust. And that is a feature that we maintain was violated because, as David White indicates in his affidavit, Auxin tried to surreptitiously replace him as the contractor on this case without his knowledge, and so that is a breach of trust. In terms of breach of the real estate purchase agreement, in section 8 sub A sub 4, there is a reference to the TIF funding. And as we've noted during my previous arguments, the TIF funding was only for a parking garage, a parking deck. It wasn't for the hotel project. And that provision specifically references the hotel project. And so there is a circumstance for breach there. Finally, there's been continued reference to this as merely a contract interpretation case, and I disagree with that. Contract interpretation is what does this provision mean or what does it say, and it doesn't require any kind of analysis of the facts or understanding of the facts. Here, there are disputed facts that must be reviewed and analyzed and weighed, and that prevents judgment on the pleadings. That prevents summary judgment. And so we submit that this is not just purely a contract interpretation case. There are facts that must be resolved. Thank you for your time, Your Honor.
All right, thank you both for your arguments. We'll take this matter under advisement. Call the next case.